You paid for it, the seller accepted your money, but what if the entire sale was invalid from the beginning? Would you still own that item? Islamic law does not allow every transaction. A sale must fulfill certain conditions of justice, clarity, and consent. Today, we discover what makes a sale invalid in Islam.
Cornerstone of the bay is the mutual consent. If there is no consent, then the bay is nullified. This is expected from the verse. Ya ayyuhallazina amanu, O believers, la ta'kulu amwalakum, do not eat, do not consume amwalakum, your wealth, bainakum, between you, bil batili, in a wrong way, in an invalid way, except an takuna tijaratan, except that you eat an taradim minkum, based on mutual consent, rida. So if there is, the second party is willing, allowing you to eat his money, to use his things, then you can use it. Otherwise, all the ways, using the other's wealth, it is considered batil, it is invalid, haram. Got it? Only if there is mutual consent. So this verse is the basis for the sale. So if there is any ignorance in the thaman, in the price, or if there is any ignorance or vagueness in the sold item, got it? So this must lead to the lack of consent. Lack of consent. If there is, for example, if there is a defect in the sold item and the seller, he did not, mention that. Yeah. So later on, the mushtari, he got discovered that there is an aib in the car. So now the consent is gone. There is no consent. He consented on intact car, on a brand new car, which is aibless, which is defectless. But he just it turns out that there is a aib in it. So now there is no consent here. So we say that this bay is fasid. This bay becomes fasid. Got it? Why? On the basis of lacking the consent. So consent is very important. So any ignorance, any vagueness in the price or in the sold item, it makes the bay nullified. Got it? So if there is no description of the sold item, there is no description for the money. So in barter trade, if the exchanged items, they are in front of you, you can see them, so you can point at them. So there is no need for description that I am selling you this kind of wheat or that kind of wheat. There is no need for description. Everything is in before you, and you can see it. Got it? So there is no vagueness. In this case, there is no vagueness, there is no ignorance that may lead to the lack of consent, to the invalidation of the sale. So in that case, the bay is jaiz, valid. So that case he is gonna discuss it here. So if the sold item and price, all in barter trade, in case of barter trade, the two things, if they are al-musharu ilayha, if they are pointed out, so there is no need to mention their quantity. Yeah. So the seller, he will say, this pile of wheat, I am selling this to you for that pile of rice. So there are two piles, so, and both can see them. So there is no need to mention how much kilos, how much kgs the both are. There's no need to mention the because everything is, and they both consented. Means the point here is that they both are agreeing on the things. Yeah. And this agreement, this consent, it does matter, not the other things. So the items that are indicated, la yuhtaju, there is no need, ila ma'rifati miqdariha, to know their exact quantity. La yuhtaju, there is no need, ila to ma'rifati miqdariha, knowing the exact quantity. Fi jawazil bay'i, for the permissibility of the sale. Yeah, so sale is permissible with that. Actually, I told you, sale cannot be valid with any kind of vagueness in it. Yeah, so there is vagueness. Actually there is vagueness because nobody knows how much kilos are the wheat and the rice. The exact quantity is unknown here, but since it is pointed out, since it is indicated, so Imam Quduri says it eliminates the vagueness from sale. It removes the vagueness. Yeah, that's why he says wal athmanu al mutlaqatu, and the unspecified prices. That is a literal translation of al-athmanu al-mutlaqa, the absolute prices or the unspecified prices. Unspecified mean they are not described. Mean which kind of gold, which kind of silver, and how much what is the weight weight of that gold and silver. If it is not described, so this is called al-atman al-mutlaqa. So in that case, the bay is not valid because there is vagueness. So the both party has to to define, to describe what is the quantity and what is the description, what is the thing. So without that it is not allowed. Well, atman al-mutlaqa, and unspecified prices, la tasihu, they are not valid, illa, unless, antakuna, they are ma'rufat al-qadari, they are known in mayya wa sifati and description. So their mayya and description must be described, specified.
Islamic business law is not just about buying and selling. It's about protecting people's rights. For more practical lessons from classical Islamic law, subscribe and follow Scholarly.